And the Court of Appeals reversed, and it held on Borland. The Court of Appeals stated that the Lotus menu command hierarchy is an uncopyrightable method of operation. Without the menu commands, users would not be able to access and control or indeed make use of Lotus 123's factual capabilities. Lotus's functional capabilities to the user serve as the method by which the program is operated and controlled. Remember that in the copyright statutes, methods are not protectable. They are excluded copyright protection. So we can see that in these two cases involving non-literal elements of computer programs, the copyright owners didn't do too well when it came to literal elements such as the copying of lines of code. Copyright owners, the courts tend to go in favor of plaintiffs. Okay, now before we go on to patents, I thought I'd spend a little time talking about in copyright software litigation. Or I call this section on a scale of 1 to 10, with 10 being best, how much do federal judges love copyright computer program cases based on non-literal elements of computer code? Let's look at, in Computer Associates versus Altai, that was decided by the Second Circuit Court of Appeals, that they have federal appellate jurisdiction over all federal courts in Connecticut, New York, and Vermont. And in that case, the opinion of the three-judge panel stated, many of the decisions in this area reflect the court's attempt to fit the proverbial square peg in a round hole. In fact, about a few months later, the Ninth Circuit Court of Appeals, remember that's 9 western states and Guam, they decided Sega versus Accolade. And the Court of Appeals, the Ninth Circuit, says, we are in wholehearted agreement with the Second Circuit's recent observation that thus far the in this area reflect the court's attempts to fit the proverbial square peg in a round hole. Now, in Lotus versus Borland, that's decided by the First Circuit here. That's Massachusetts, Maine, New Hampshire, Puerto Rico, Rhode Island. The court stated that copyright law to computer programs is like assembling a jigsaw puzzle whose pieces do not quite fit. In fact, federal judges aren't even in agreement on how to describe how they dislike these cases. They talk about, like, if you're in one circuit, it's the jigsaw puzzle whose pieces don't fit. If you're in another circuit, it's the square peg in a round hole. In fact, in Lotus versus Borland, there is somewhat of a sequel. After the Court of Appeals decided in favor of Borland, Lotus, which lost, asked the Supreme Court to hear the case. Now, the Supreme Court will only hear cases if the losing party at the appeals court level files a petition to ask the Supreme Court to hear the case. And the petition has to be granted. The Supreme Court only grants maybe 1 to 2% of all the petitions that are submitted to it. And then once the petition is granted, then the losing party has to brief the case, have its lawyers show up, and convince 5 of the 9 justices to reverse. Well, the Supreme Court did actually hear the Lotus versus Borland case, and in 1996, they rendered a decision. Justice Stevens did not participate, for not clear in the opinion. Of the remaining 8 justices, they split 4 to 4. In fact, they didn't even have like one group said, this is why we hold for Lotus, and the other 4 said, this is why we hold for Borland. They just had one memorandum opinion. And in the memorandum opinion, the court stated, the court's non-action calls into question the First Circuit's decision and suggests that the issue likely will find its way back to the court in the relatively near future. Now, this was in 1996. I haven't been able to find any Supreme Court cases involving copyright protection of computer programs, non-literal elements since then. Maybe after this they decided maybe we don't want to deal with this anymore. Maybe they're too busy deciding who to be president. They just don't want to have anything to do with this. But if you do the vote count, you can get an idea how much tension there is amongst the members of the judiciary. Recall that in Lotus versus Borland, Lotus won at the trial, so that's 1 for Lotus, 1 judge for Lotus. 3, it went up to the Court of Appeals, and the 3 Court of Appeals judges held for Borland, so that's 3 for Borland. And then when it went to the Supreme Court, they split 4 to 4. So that means that that's 5 for Lotus and 7 for Borland. So if the vote count is in, Borland just won by 7 to 5. And you know, you think that the Dennis Kozlowski Tyco jury was having trouble making up its mind. I kind of wonder, eventually these people, someone's going to have to bite the bullet. But as things stand right now, protection for copyright protection of computer programs based on non-literal elements, it's very difficult. The courts tend to go in favor of the defendant. Literal copying, the courts tend to go in favor of the plaintiff. There was an interesting statement in Computer Associates versus Altai. The court said, patent regulation with its exacting upfront novelty and non-obviousness requirements might be the more appropriate rubric of protection for intellectual property of this kind. What the court is saying is, think patents. In fact, people had been thinking patents for quite a period of time, except that the patent statutes appeared to be somewhat, well, they were interpreted somewhat negatively toward software-based inventions. Let's talk just a little bit about patent law, particularly as it pertains to software-based inventions. A patent is a grant from the government that gives the inventor the right to exclude others from making, using, practicing, selling, or importing the patented invention. Now, in order for someone to obtain a patent, there's a threefold test of patentability. The invention must meet the test of novelty. It's got to be new. That's the creative part. Second is non-obviousness. Now, I kind of wondered how I was going to explain this. In the day-to-day operation of the Patent Office, in the day-to-day practice of patent law, we've come to see how the concept of non-obviousness applies so that we can use it. For example, if a first inventor invents a digital computer circuit, in response to an input, it produces an output which is a binary one with a square wave pulse going from 0 volts to plus 2 volts. And let's assume the second inventor invents the same digital computing as the first inventor, even perhaps without knowledge of the first inventor. And the second inventor's invention produces a binary one output pulse where the binary one is represented by a pulse going from plus 2 volts to 0 volts. So you can see that in the second invention, it's identical to the first. The only difference is that the output pulse has a polarity that's reversed. So it looked like the second invention would be obvious over the first.